My name is Marlene Ames. I am a heterosexual woman. I have worked for the Ohio Department of Youth Services since 2004. In 2019, I interviewed for a management position, but a lesbian woman was hired instead. A few days later, I was demoted, and a gay man was hired to fill my old role. I believe my employer discriminated against me due to my sexual orientation, which is impermissible under Title VII of the Civil Rights Act of 1964.
No. To prevail on a Title VII claim, you must make a prima facie showing that your employer acted with a discriminatory motive by pointing to facts that, if otherwise unexplained, are more likely to suggest illegal discrimination than not. In order to do so, a straight employee must demonstrate background circumstances supporting their suspicion that their employer is that unusual employer who discriminates against the majority by favoring gay employees over straight ones.
That's ridiculous. I shouldn't have to meet a higher standard to prove my case because I'm straight. Claims of discrimination against members of the majority should be treated the same as claims of discrimination against minorities.
I'll be the judge of that. The question before us today is whether majority group employees must identify background circumstances, supporting the suspicion that their employer discriminates against the majority in order to win a Title VII case. And our answer is
no, majority group employees do not have to identify these background circumstances.
We concur.
What? How did you make that decision?
In McDonnell Douglas Corporation versus Green, we created a three-step framework for determining intentional discrimination by employers. In the first step, the employee bears the initial burden of proof for discrimination. They must establish a prima facie case by producing enough evidence to support an inference of discriminatory motive. If Ames were gay, she could have easily satisfied this requirement by showing that she was qualified. She was denied a promotion in favor of a straight candidate, and she was later demoted in favor of another straight candidate. However, because she was a member of the majority, she was required to meet an additional background circumstances requirement. The Sixth Circuit ruled that due to her sexuality, she had to satisfy a higher evidentiary standard by providing specific types of proof that her employer discriminated against straight employees, such as statistical evidence of said discrimination, or evidence that an LGBTQ person made the employment decisions at issue, while a gay employee would not be required to provide such proof. This heightened standard for majority group employees is inconsistent with Title VII's text and this court's precedents. Title VII makes it unlawful for employers to discriminate against any individual because of such individual's race, color, religion, sex, or national origin. This language clearly provides protection for any individual, regardless of whether they are a member of a majority or a minority group. This court has several precedents reinforcing this interpretation. In Griggs v. Duke Power Company, we stated that Title VII disallows discriminatory preference for any group, minority or majority. In McDonald v. Santa Fe Trail Transportation Company, we stated that Title VII prohibits racial discrimination against white employees and black employees alike upon the same standards. With all this in mind, we cannot support an unequally heightened standard for majority group employees to prevail on Title VII claims.
I concur in full. I write separately to point out that this case involves two improperly judge-made rules. The Sixth Circuit's background circumstances rule and this court's McDonnell-Douglas framework. In an appropriate case, this court should consider whether the McDonnell-Douglas framework is an appropriate tool to evaluate Title VII claims at the summary judgment stage.
Regardless, Title VII does not impose a heightened standard on majority group plaintiffs. The judgment below is vacated, and the case is remanded for application of the proper prima facie standard.
You rule, Supreme Court.
You suck, Supreme Court.